Hi everyone. Today we are talking about what you should do to help yourself when you get to court, and then the opponent or the other party you brought to court keeps lying. He will lie and lie and lie. What are you going to do? Are you going to raise your hands in the air, or you can make some preparations before you get to the court so that it will make your work easier? Uh-huh. That's what we are learning today. So sometimes people think that when they go to court, there are some facts that the other person will not deny. And I always tell them that you would be surprised because at the courtroom, people can deny so many things, including even the fact that they know you. Sometimes they will say, I don't know this person from anywhere. In case it's about monetary issue, maybe the person owes you some money. The person can come and say, I don't know Lawyer Tina. I never took any money from Lawyer Tina. And so he's just making some fabrications on me just because of this, that. What will you do? Now, the law says that if you are the one coming to court, and if you are the one saying that something has happened, you have to prove that something has actually happened. And I'm saying this in respect of civil cases, civil, debt recovery, land matter. If you are saying that this land is yours, the burden is on you to prove that this land is for you. Do you have what it takes to prove to the court that the land is actually yours? If I go to court and I say, oh, maybe Stella owes me 10,000 cedis, and Stella says, oh, yes, it's true, then it means we are all good. We don't even have to stress. The court will just say, okay, Tina, Stella, when are you paying this money? The court will make an arrangement and then the money will be paid. That you are lucky. It means that the person has admitted that he owes you. If Stella also confesses somewhere that, oh, I owe Lawyer Tina something, maybe you have a chat, a text message, they wrote a letter saying that, oh, I owe Lawyer Tina. That one too is a confession. You are lucky. It can be within the court, it can be outside of the court, but you are lucky. But then, most likely when you go to court, people are bound to say, I don't know Lawyer Tina, I never owed him any money. And so that is what you're supposed to prove. Look for evidence. So how can you prove that this person actually owes you money? The law says that you can use documents, you can use oral testimony. If there was a witness there who saw it, the person can come and give a testimony that, oh, it's true, like Tina gave some money to Stella. Stella said she paid this amount, that amount, and then she never paid. If there is scientific evidence to show that the person actually owes you, you are good. Scientific. DNA, maybe when they came home, it is something scientific to show. If there are pictures, there are videos, demonstration, anything that can be visible to the eye, to the senses, for us to know that this person actually borrowed money from you, you can use that. Yes. And so it means that if you are dealing with someone now, deal with someone based on documents, based on witnesses, based on trusted documents, pictures, videos, so that one day when you need to prove your case, you will get something to rely on. If not, you rush to court and then you may not be able to prove your case. We have what we call scientific evidence, we have what we call traditional evidence, and then traditional evidence is when maybe there is something about the history of a particular land and everybody involved is dead. There are no documents there. Somebody can come and tell the story of what happened and who came to take over and all and blah blah blah. And then it will come and reflect what is actually happening in recent times. Then the judge will say, oh, it's true. It was this chief who handed over to this chief, and now his son is taking over. Right? So traditional evidence. Then we have what we call circumstantial evidence. Usually we use that in criminal cases. Somebody has gone to kill somebody, and then we saw somebody there with the colors. That person's hand were with blood. The person died with colors. There was no other person closer to the scene apart from this other person. Then we're like, oh, okay, as for this one, then there's no other person than you, unless you can get a better explanation. Right? So that's circumstantial evidence. Always remember that in a civil matter, the court is looking at whose evidence is more probable, whose evidence supports his case in a more probable way than the other. So if we are doing this, you see that the lawyers, we have a scale, usually on our symbols, judicial service, there's a scale like this. Who should the balance tilt in his or her favor? So if you're able to prove that your case is more probable, the judge may be on your side. Always make sure that your evidence is relevant. Sometimes you go to court and you say so many things which are irrelevant to the case or irrelevant to the facts. We are talking about land boundary, then you're talking about your relationship with the person and how you had sex. It has nothing to do with the land matter. Be focused. If you're talking about land matter, be focused. You're talking about divorce, how you should share the property. Don't be going to talk about how the man abused you in. No, don't say things that are not relevant. Say things that are relevant for the court to know that, okay, based on this and that, this land belongs to this. This property should be shared between this and that. If not, you may say irrelevant things and you may think that, oh, you have said everything in the courtroom, so they should give you the land or they should give you the property. But your testimony was not relevant. Now, how do you know your testimony is relevant? Your testimony is relevant when it is giving more reasons to prove that your case is true. It is supporting the facts that you are saying. Or it is discrediting the evidence of your opponent. So get documents, get videos that will support your case or your facts. Then get things or documents which will disprove, which will show the court that what the other person is saying is not even probable, it's not even true, it is unlikely. There are so many things that are important in the courtroom. One of the things that are extremely important is cross-examination. Now, cross-examination is the opportunity that is granted to the other party to ask questions based on the testimony of their opponent, right? So somebody has written a statement and has brought it to the court. It looks nice. Other documents. The court is asking you that, okay, all this evidence that the person has brought to court is against you. Now show the court reasons why we should not accept her evidence as proper or more probable. So what you do is that you ask questions that will show that what they are saying is not true. They are lying. They have some bias or motive. They have faked some of the reports or some of the documents, or what they say it means does not really mean that, right? You can also show that the person who is even giving the evidence is not credible. You can't even trust that person's statement on oath because they are lying or they have lied about something or they are being inconsistent with their evidence, or they are not even able to recollect or recall some of the things that they said they saw. The person said, I have good eyesight. I saw this from a far distance. You should ask questions that will show that your eyes are not even good. You could not have seen. Or it was dark. You did not see my face well, right? Or you should also show that, oh, this person, you said this in paragraph A, right? And you are saying this. Or when we went to the police, you said this. Now you are saying this. You are being a liar. You are not saying the truth. Draw the attention of the court to the untruth in their evidence. If not, you are doing yourself. And I'm telling you, this is a job for lawyers. Lawyers have been trained to do cross-examination. Yeah. And there are very good ones. So if you want to have a good case, they are best off if you give the case to a lawyer to handle it, because the lawyer knows what to show to the judge for the judge to know that, oh, this is not true. This is not probable. Now, sometimes after everything, the court may be left with only two testimonies of people who are swearing on oath that will say the truth or will say the truth. The court is going to look at the lies by the other party. The court is going to see how inconsistent they have been. The court is going to see all the questions that have been asked and all the answers that have been given to be able to show which of the two parties who were given evidence for each side was more truthful or was more credible. And the court will choose which one they believe to be more probable. But then they have to give their reasons. If the judge gives his or her reasons and you are not comfortable with it or you're not happy with it, please, you have to appeal to the next court. It can be the High Court, the Court of Appeal, the Supreme Court. Just appeal. But make sure you have a lawyer at the trial court or the lower court to ask proper questions for you, to put in proper evidence for you, so that when you go on appeal, it will be easier for you. But if you have any evidence, please bring all the evidence in the first court that you went to. Because on appeal, if that evidence was available and you didn't bring it, the court in appeal will not request for new evidence. I know you have questions. Let me know what your questions are in the comment section. I will answer them accordingly. Until we meet again, have a very, very, very good time. Bye.